two or more specific industry-oriented, technology industry-oriented issues. One is the GDPR and blockchain. So there is a conflict between the blockchain and GDPR. This a very concept is like that. In blockchain, basically we know that blockchain is immutable. But blockchain, in one side, the blockchain can help to make the data secure, because the data within the block and is a doubly hashed and doubly secured, and is that. And another thing is that blockchain is immutable, so that the information in the blockchain cannot be changed, and it is decentralized, while the GDPR is designed for centralized organizations with controller and processor. So there are two type of problems will come in case of growth of blockchain and use of blockchain in processing and keeping the data, and that is in case of portability or right to be forgotten, which is one of the important issues, which are the important issues of GDPR. In case of the compliance of the data portability and the right to be forgotten, right to be deletion or on all these will be a great challenge in case of GDPR being complied in blockchains and all this, because blockchain, the informations in the blockchain cannot be changed, and it is always decentralized. So these are the issues which is important in case of blockchain and GDPR applications and GDPR compliance. Again, GDPR wants right to be forgotten, while in blockchain the information and data cannot be changed. This is another issue. Again, a person participated in blockchain in strict sense of GDPR are controller, and the blockchain itself is a processor. So if the immutability of a blockchain or the blockchain being decentralized will come in the way of GDPR compliance, come in the way of GDPR and compliance with the GDPR, then what is the way out? Whether the GDPR is going to amend in case of specifically for blockchain applications, or the blockchain technology will change itself to accommodate the GDPR. The future will obviously going to tell, because it's a important issue today. Now coming to the GDPR Internet of Things. So Internet of Things is a Internet of Things, or also called the IoT, has seen a phenomenal growth, and it is estimated that by the year 2020 there will be nearly 50 billion IoT connecting the internet. A lot of thousand and more protocols are there. There are small devices which are going to deal the data and all the sensitive things. So among the various legal challenges the IoT is going to face, the data protections and security and the information privacy are the most prominent one. In case of IoT using the connected devices, there is a lack of control on the data and the information, and in many of the cases the user are not aware of the use of their data without their consent. So this IoT and the use of the data in case of connecting the IoT with the internet and use of the IoT and dealing and processing with the data, the GDPR will definitely have a very important role to play, and that is also another big challenge to implement. And with the inception of GDPR, the growth of IoT is getting challenged, because the IoT devices from the beginning to the end, it has to be GDPR compliant. So with the implementation of the GDPR concerning privacy in the internet, the applications and growth of IoT must require a thorough information assessment as to the use of personal data of the user. So the way GDPR is going to greatly affect the way the internet devices being manufactured, and this smart internet of IoT devices, the smart devices being manufactured, and the use and change the business module behind it. So GDPR will going to affect from the beginning to the end of the entire Internet of Things structures, from the day of planning and manufacturing the smart devices till the date of implementing the same. So this thing is important, and this conflicting with the GDPR is obviously to be addressed, and the requirement of data portability and the right to be forgotten is hard to comply in case of application of smart devices. So that is also another challenge with the GDPR in IoT. The smart devices builders device builders requires to be more concerned about the personal data of the user. So in order to face this challenge and this thing, this smart starting from the hardware point of view to the software application point of view, everywhere in the entire trail, the more emphasis is to be given for personal when the personal data of the user is being used. Now, from the design to manufacture and final disposal in whole lifestyle of a smart device, the data privacy policy should be taken care of in order to comply the GDPR, which will be more ethical also. So, if again the same issue, same concept will come up. If the IoT become the entire structure of IoT, the hardware, the inbuilt software, and its workings, and all this. And its connections with the internet, is use of the data of the personal data of the individual. If all apply to the GDPR compliance model, then in the days to come, the IoT will become more ethical and will be ready for to face all this future challenge. So, as per 2016 survey, about 2/3 IoT devices does not meet the proper standard. Conflict. There are challenging issues between the application of the cloud or cloud servicing providing companies and their workings, how they deal with the data of the person and the GDPR. So, in GDPR, both controller and processor of personal data are liable. Hence, the clouds are not exempted from the GDPR enforcement. So, cloud is coming very much within the purview of the GDPR compliance. So, the cloud servicing companies has to comply the GDPR regulations. So, cloud service companies even located outside the European Union need to comply the GDPR if they deal with the data with the EU citizen. Data collected from the customer should not be more than that mentioned in the predefined purpose for which the consent has been obtained. All data in the cloud should be managed in line with the GDPR. And even the companies who receive the cloud service are also responsible for violations or infringement of data in the same way as the cloud service provider, and the clients of the cloud service provider are also required to safeguard their data and see that the cloud provider comply the GDPR. So, in companies who receive the cloud services are also responsible for violations or infringement. And so, if we use the service, take any service from the cloud, I am also responsible for compliance of the GDPR to the organizations. If the data is not further required, and in case of cloud, reusability and repeated use of the same, and if the data is not further required as per the GDPR, it should be removed from the cloud, and we have to use the data for the purpose for which the approval or consent is being obtained. The non-GDPR complying mobile or web application should be blocked from the system. So there are in our system we use the different mobile application or web applications which does not comply the GDPR regulations. Then those applications should be blocked from our system as well. So again, another very sensitive issue is the conflict between the GDPR and the big data analytics. So I've already discussed about this in a nutshell previously. Now, since May 2018, when GDPR came into being effect, people started to apprehend that the progress of big data analytics will be somehow slowed down, somehow it will be halted or temporarily stopped and all this. But experts are of the view, they are very optimistic. They said that the big data would obviously survive any kind of impact, and that may be the impact of the data protection laws. On the other side, the GDPR and similar data privacy laws will obviously going to create a trust in the data analytics process. So it's not that they're all pessimistic thing; there are optimism as well. So since May 2018, when GDPR came into being, people started to apprehend that the progress of big data analytics will be slowed down. So this is one side, there's an apprehension, there's an optimistic tone that the big data will obviously survive in any given impact of the data protection law. So that is there. On the other side, in one side the GDPR, in one side there is a challenge between the workings of big data analytics and the compliance of GDPR. And on the other side, if these big data analytics companies are complying the GDPR, then they will be better prepared for the future, and they will create the trust in the mind, create the trust. Thorough privacy impact assessment of the existing data model is required for the compliance of the GDPR. So we have this compliance is required in this way. The process of big data analytics has to comply the GDPR when they are processing the personal data of the people of the European Union, which has already been discussed in many ways. And the people of the European Union have to be explained specifically and in a very unambiguous way the purpose of use of personal data when the consent is obtained. So this has to be kept in mind. Now finally, the big question is whether India is ready or not for the compliance of GDPR. If you go by the history, you will see that India doesn't have a long historical background of dealing with the privacy law like the European Union's story. In European Union, the privacy law has a more than 30 years history, and they are more prepared to deal with this privacy legislation and all this, which the India doesn't have, because we only got the right to privacy as a fundamental right, Puttaswamy judgment, and before that there was no clear findings or clear rulings or clear that the privacy is a part of fundamental right, or privacy is a fundamental right to us, and part of our, Article 3 of Indian Constitutions. So now the things are changes, and we are just making our journey through GDPR compliance and for personal data compliance of the EU. We need to be GDPR ready to save our business as well as to make data privacy, or as Apex Court said, information privacy or information good practice culture, which will in the this culture, this good information data privacy or data information good practice culture, which will in the long run help us or our corporate in many ways. There is a debate that whether our personal data privacy bill is a copy of the GDPR or not, but that is not the real issue. The real issue is that whether we are ready to comply with the regulations, or our corporate who earns the livelihood processing or dealing with the EU citizens' data will collapse, stop the business in European Union, or they will stand up in the competitions and say we are ready to comply with the GDPR, we are ready, we are GDPR compliant, and will invite all the Indian entities and who are directly and indirectly connected with the entities, the government policy missionaries, to give a very serious thought in compliance of GDPR, because it's a trial procedure, it's a trial process, and it's a preparatory process. And if we already that GDPR has came into in the year 2018 May, so 1 year has already been elapsed, and it is a high time whoever have not taken the GDPR seriously, please take it seriously, so that the manifold benefit of a GDPR compliance will come to us. At the end of the day, we will become more competitive, we will become more efficient, and India will rise to the top. So with this tune, obviously the future will tell how much we're going to get success. Thanking you all. That's my details, and you can access me to the information I have given in my about page in the YouTube, my YouTube channel. So thank you. So friend, after hearing the discussions on this GDPR, it's a very important issue today, and I want to invite your comments on this point. What kind of difficulty you are facing in your business and your entity, and for a common people, how your data has not been secured, and what will be the effect, what are you thinking about your fundamental right because after already discussed about it, after the Justice Puttaswamy judgment, fundamental right has been right of privacy